The vicarious liability. Every person is liable for acts the person commits and not liable for the acts done by others. But in some situations when a person is liable for the acts of another person is known as vicarious liability. So, for this to happen there must be a specific kind of relationship between both the people and the act must be connected with the relationship. These relationships can be of a master and servant or principal and agent. Vicarious liabilities only deal with the situation where the person is liable for some other person's acts. It is considered as an exception to the general rule that the person is liable for his acts only. Vicarious liability is based on the principle of qui facit per se per alium facit per se, which means he who does an act through another is deemed in law to do it himself. Essentials of vicarious liability. There must be a certain type of relation between the parties. The wrongful act must be committed by another person. The wrongful act must happen during the course of employment. Relations in vicarious liability. Master and servant. Owner and independent contractor. Partners in partnership firm. Principal and agent. Company and its director. Reasons for vicarious liability. A servant is just an agent who is controlled and supervised by his employer. The master always enjoys the profit derived from the efforts of the servant. The master is financially stable than that of a servant. Types of vicarious liability. Principal liability. When a person allows another person to use his vehicle to perform a task for the owner and while doing the task, the person causes damages or injury through negligence. In this case, the owner is liable for the damages through vicarious liability. Parental liability. A is the mother of 10-year-old B. While performing the daily chores she was not able to keep an eye on B and B damaged the car of C. In this case, A is vicariously liable for B's actions as B is the son of A and she has to keep an eye on B's actions. Exceptions. When the servant is under a statutory duty which he cannot delegate, the master is not liable. When there is a case where the servant is involved with the withdrawal of support from the neighboring land, the master is not liable. When situations involve very hazardous acts, the master is not liable. When situations involve escaping from the fire, the master is not liable. When situations using the highways, the master is not liable. Conclusion. Vicarious liability deals with only those cases when one person is liable for the actions of another person. And the liable person must be superior to the other person. The person who commits wrong must be in the course of employment. The course of employment is essential for vicarious liability.